Hi, everybody. Thank you for coming. This is the World Campus Technology Club. My name is Ray. Our guest tonight is Mary Chaney with her talk, Time to Get Remarried. Turns out cybersecurity and privacy are still in love. Welcome, Mary, and now you can take this.
Well, hello. Thank you guys for having me. I really appreciate you guys taking the time out to attend, and we can talk about this session. So about myself, my name is Mary Chaney. As pointed out, I am a CISSP and a CIPP and a lawyer. So essentially, the background, and we'll go through this a little bit, during the timeline that I have for this presentation, but essentially, I'm an engineer by trade, so I have my undergraduate degree is in information systems. After undergraduate, I did attend law school, and after law school, well, when I was in law school, the FBI actually came recruiting to our law school because at that time, and I don't know if it's still the case. I haven't looked into it in a while, but you can actually, one of the ways you can become an FBI agent is through their JD program, and that means a law degree, not necessarily being a licensed attorney, but having a law degree. So my thought was, I'm not going to go through 3 years of pain of being in law school without taking my bar exam. So I actually took my bar exam back in 99 and kind of sort of shelved it a little bit as I pursued my FBI career. So I went into the FBI and I investigated cybercrime. Went to the FBI in 2002 after September 11th. Put me on a cybercrime squad, and I was shipped out to Los Angeles, where I was doing all kinds of crazy stuff out there. It was lots of fun. But what my day job was investigating cybercrime. So I was able to do denial of service attack cases. I did some auction fraud because eBay was big back then. I actually did some intellectual property rights infringement cases and things like that. Before transitioning out of service and had my first stint as an entrepreneur back in 2008. And then once I ran out of money in 2012, I had to get a job. So I started my corporate journey in 2012. I held executive roles for GE Capital, Johnson & Johnson, and Comcast. So for GE Capital, I was the director of incident response, which is kind of sort of a misnomer. I had incident response, I had security awareness, I had data leak prevention under my purview. I had database security as well under my purview for them. And then after transitioning out of GE Capital, I went to stand up and run the Security Operations Center for Johnson & Johnson. So essentially was responsible for bringing together their worldwide Security Operations Center, including resourcing it up, hiring and getting people, focused on the right things. I had a short stint with Comcast where I was at their global CISO's, Chief Information Security Officers organization, and did a number of things in regards to efficacy as well as unstructured data and things of that nature for both Comcast Cable and NBC Universal. And so back in 2017, I decided that my corporate journey was over. And so I had that law degree. Remember, I told you way back in 99 that I was licensed to practice, and I decided that I wanted to start my own cybersecurity law practice. So that warranted a move back to Texas because there's absolutely no way that I was going to take another bar exam. That was out of the question. So moved to Texas and started my own law practice utilizing my information technology engineer background as well as my legal background as well as my investigative experience while I work for the FBI, and then we can get into the entrepreneurial business aspects as well. So what we'll go from there, we'll talk about, I do put this slide in there so I don't forget. I'm also, from the community perspective, the chairman and CEO of an organization called Minorities in Cybersecurity. Essentially, it's a leadership organization where we're teaching individuals that are entering into the cybersecurity field as well as individuals that are transitioning into the cybersecurity field, leadership training skills. I mean, there are a lot of organizations out there that are doing many things in regards to technological advancements, certifications, and things like that, but there's a soft side to it that, you know, as you now start to build out your career in this particular field, support that you may need. So this is one of my babies that I actually, another one of my startups I started in August. So we're making some good progress, have some good calls. We have monthly community calls and things like that. So I'm trying to make sure that I'm giving back to the community in that regard. So, of course, the name of this particular presentation is Time to Get Remarried. Turns out cybersecurity and privacy are still in love. So essentially what you have is my timeline in this space. So to understand where I'm coming from, you have to understand what's been going on. And when I was doing this timeline, it was pretty interesting how it kind of sort of lined up to my personal life in general as I started putting these things on this timeline. Because 1994, the CISSP comes out. That's the Certified Information Security Information Systems Security Professional Certification. That came out in '94. That was the year I graduated from college. And then HIPAA came out in 1996. HIPAA is the Health Insurance Portability and Accountability Act. And I did that wrong. It should be HIPAA, not HIPPA. I did that wrong. Okay, I did it wrong on this timeline. I did it. Okay, anyway, it doesn't matter. I need to correct that. But in any event, that came out in '96, and like I said, that was the year I went to law school. The Gramm-Leach-Bliley Act is an act from banking perspective, and it teaches banks, or it has requirements on banks on how they protect information from a cybersecurity perspective, and essentially it dictates how an organization or what an organization should be doing in regards to protection of that particular banking information. And then you had FISMA. FISMA is the Federal Information Security Management Act, and that applies to the federal government. So 2002 is when I actually went into the FBI. So I grew up with FISMA. I mean, that's when I started my information security and privacy journey. You'll hear me use the word information security. Please understand that that is actually the same in my mind with cybersecurity. They rebranded it a few years ago to be cybersecurity, and there are your purists like myself that believe information security is all-encompassing of cybersecurity and privacy. So you have that's essentially when I was within the FBI, I had to deal with FISMA, and FISMA encompassed everything, right? So I grew up in the FBI where everything mattered and everything was surrounding the data. Data, what kind of data it was. And we couldn't even build a building because I was the collateral duty while I was a special agent. I was the Associate Chief Security Officer. And so that means I was responsible for the security of the information of everything in the Los Angeles field office. And so we couldn't even build a building without knowing the type of data that was going to be stored in that building. So the type of classification level of the data, it depended on the requirements of the actual building, whether the ceilings went all the way up to the top, whether, the HVAC system you could get through. Think Mission Impossible, Tom Cruise with the HVAC coming down. All of that stuff was had to be under consideration depending upon the classification of the data. If it was unclassified information, it's not as stringent. If it was SCIF information, which is sensitive compartmentalized information. And so you had that facility had to be different and had to be locked down from a different perspective. So that was where I grew up. That's the place that I learned information in cybersecurity and privacy because it just it wasn't separated. So the relationship between cybersecurity and privacy started to get complicated with HIPAA. The HIPAA privacy rule comes out, and then you have the CIPP. The CIPP is the Certified Information Privacy Professional exam. And so what has happened over the course of the years, and what we'll talk about throughout this conversation, is the divorce between the cybersecurity aspects and the privacy aspects. Cybersecurity tends to be on the technical side. Privacy tends to be on the legal side. And it's a problem because breaches continue to happen. And so the CIPP comes out, and then the HIPAA security rule comes out. So the privacy rule has to deal with the type of information, the healthcare data, who they can share that information with. The security rule says you need to have an incident response plan. There are certain things that you have to have in order to be compliant with the Healthcare Act. So about 2008, I left the government, and then I started to transition into the private industry. And for me, my transition from government service to private industry is when I saw the fact that there was this divorce that had happened between cybersecurity and privacy. Again, I grew up them being married, and then I get out of the FBI, and it's like, oh my God, what's private industry doing? And then that's even when I was interviewing transitioning out of the FBI, there were private industry companies that would not even I was getting the feedback from recruiters that they wouldn't even consider my resume because I was from the federal government, and it was, well, they're coming from the government. They think of things in a different way. It doesn't translate to private industry. Of course, that changed between 2008 and today, mainly because, of course, you had the Target breach. The Target breach happened, and everybody said, oh, my God, what in the world is really happening on the IT side? That's when information security, cybersecurity, IT, all of that, there was a flashlight, because it becomes, how in the world is it possible that your HVAC vendor has access to your point-of-sale machines? And that was a key moment in this chronology in regards to what in the world has the IT folks been doing that they ever have allowed this to happen. So then, of course, what you have recently is GDPR. GDPR comes out, and everybody loses their mind. And if you're not familiar with GDPR, and I'm making some assumptions here about the audience, I don't want to do so. If you have questions, if you need clarifications, please, say something in the chat. But GDPR is the General Data Protection Regulation that exists in the European Union. It is a privacy legislation that essentially touches on cybersecurity aspects because the European Union takes a different privacy stance than the United States, and we'll get into that. But essentially, by this year, just between January and June of this year, there had been 4.1 billion records compromised. And so where are we? Where are we? What are the current privacy trends? What exactly are we doing to do something about the fact that the data that we're sharing as citizens is routinely being exposed through breaches? Okay. So here we go. Let the battle begin. So here's the problem. So from the information security / cybersecurity side, and I'm gonna switch between my geek hat and my legal hat. I'm gonna wear my geek hat right now, which is geek hats. We're heavily steeped in frameworks. We started off in '83 with the OSI model. The OSI model is just a model that shows what goes from physical security all the way to application security. I'm sure there's some geeks on the phone that can rattle off, each level of the OSI model. But essentially, from a technology side, we have been looking at bits and bytes, not necessarily the actual data, just bits and bytes, whether or not we have availability, whether or not it's working, whether or not the communications are working between systems. As we build out networks, we're worried about the blinking lights being green instead of red. And so you have all of these frameworks that are out there that try to teach an organization what they should be paying attention to when it comes to cybersecurity. You have OSI, you have the ISO, you have FISMA, you had the OWASP Top 10, and then you have NIST. NIST came out in 2014. And these are all these are all ideas. These are all goals that one should have if one is looking to now tackle information security, cybersecurity holistically. You can use a framework to actually figure out what you should be paying attention to. It's still fuzzy because there's no, this is what you need to do, right? There is no, this is the type of firewall you buy, this is the type of encryption standard you have, this is the type of network or infrastructure that you should have, period. It's vague, right? And we've lived on the tech side, on the security side, in obscurity. We've been using all of these fundamental terminology and speaking and geek speak, so to speak, and talking about whether or not the firewall that we have is up to date and where is it sitting in the DMZ and how, and so we've been talking that technical speak, and it's not translated to the executives that are running the business. And then we do this fancy rebranding all the time. The cloud is the perfect example. They talk about the cloud. There is no cloud. It's just somebody else's computer. You're just renting somebody else's computer. And so if you have problems on your on-prem or in your organization itself, going to the cloud is not going to fix those problems. It's just vulnerability switched from your house to somebody else's house. Now, now we're going to switch to the legal side, and they speak Latin. So what you have is you have geek speak, and then you have Latin. So what you're having within privacy laws in general, that's legal folks talking legalese, talking about contracts and regulations and things like that. So what I want to do is ground you guys in understanding what the difference is in privacy laws. In privacy laws, for instance, your GDPR, for instance, GDPR is a comprehensive privacy legislation. What that means is it doesn't matter what you do as a business if you collect data about individual citizens that are in the European Union, you have to treat it a certain way. It's comprehensive. Essentially, it's steeped in inequities that have happened in the past, going all the way back to the Holocaust. And that's basically, in my opinion, why the EU is so sensitive from a privacy perspective, because if you reach back, if you think back, or if you research what happened, all of this information was collected about individual citizens. Hitler went in through the rolls, so to speak, and found where all the Jews were, and that's how they started to this atrocity that happened that was the Holocaust. So their view of an individual's privacy is different from the United States because we don't have those types of atrocities in our past. So our laws in the United States are sectorial, meaning there are certain sectors of the industry that's regulated. Banking is heavily regulated. Healthcare is heavily regulated. Children's privacy is regulated. Don't get me started. I have children, and I understand the gaps of our children's privacy laws. There's facial recognition going on at schools, but we're not going to get into that right now. And then you have telemarketing. Those are, generally speaking, the 4 areas that the federal government actually gets into or gets involved in privacy through the FTC, and they are actually enforcers of these laws. So to think about the FTC and how that plays into our laws here in the United States, the FTC is responsible for unfair and deceptive trade practices. And so how they actually are enforcing privacy, let's just take Equifax, for example. They come in after the fact and they actually review what happened, and then they say, well, you said in your privacy policy that you were protecting this data. Well, you weren't, so that's unfair, okay, to the average consumer. The average consumer, if they knew that you weren't living up to the responsibilities that you held out that you were doing, that you're not being clear, is deceptive of how you're actually complying with this privacy statement. And so that's how the FTC goes in, and that's how they did with Equifax. They went in and did an investigation after the fact, because Equifax is not a regulated entity in that it's not banking, healthcare, children's privacy, or telemarketing. So any industry, Facebook, any industry out there that you can think of, Yahoo, all of these entities that you can think of right now that have had breaches, most of them that are not in any of these 4 areas, the FTC will come in and they will say, you need to do better. So the Equifax has to spend, millions of dollars on their cybersecurity program now, because the FTC came in and did an investigation and found out they were ineffective. So I'll stop there and breathe. I'm going to stop there for a second because I've been talking real fast. Is there any questions that anybody has up until this point? No, we're just going to go with silence. Okay. Hopefully you guys can hear me.
We can hear you. I can hear you.
Okay, good. And so what's happening from a privacy perspective from the states? So now you hear about California Consumer Privacy Act, CCPA. California has been one of those states that has been really active on privacy, individual privacy. And California's law is more like GDPR in that it's comprehensive, which means it applies to anyone in the state that actually, or out of the state, that has California citizens' data. California was the first that had their data breach laws, and we'll talk about that as well. So California has been on the forefront of all of these things when it comes to individual citizens' privacy. Texas, and I have Texas stuff in here just specifically because I'm in Texas, we have some privacy legislation that will be reviewed in the 2020 legislative year. And some of them, the Texas CPA looks like the California law, and the PPA looks like a different law. We don't have to get into the specifics of that from a legal perspective. But what's happening and what you guys need to understand is because the federal government is not really doing anything about it from a overarching, we need to regulate or tell people how to deal with data in all industries. The states are now coming in and saying, okay, if you have our citizens' data, this is what you need to do, which has big tech, large companies, and it leaves them in limbo, because what we'll learn a little bit later is, just like in data breach laws, we don't want 50 states coming up with 50 different privacy legislations that each business that has citizens' data of, if you're a multinational or if you're just, a United States company that does business in multiple states, you have multiple privacy legislations that you will actually have to comply with. So there's a push from a federal perspective, to create something, some sort of privacy legislation. I think the count now is up to 5 that are on the books right now that are being considered by the federal government. They're all different. They all have different flavors and things like that. But I'm not confident that anything is going to happen in the next year or two. It just doesn't seem that they're focusing in on the necessity to create some sort of federal level privacy legislation. The big tech wants it preemptive. What that means is, instead of having 50 states coming up with their own privacy legislation, they want a federal legislation that applies across all states, so they don't have to worry about complying with individual states' requirements. But that's still uncertain. The funny thing about it is most privacy legislation that is on the books at a state level, even at the federal level, with all of the ones that you see listed on this particular slide, they require you to protect data, but they don't tell you how. They don't tell you how you're supposed to comply with this particular privacy law. It's still left to you, which is the vagueness, again, on the legal side. And then there's also no private right of action. What that means is, and be mindful of this when you're looking into this, if an individual citizen doesn't really have a right to sue for a company having a breach, they will say that the reason that is because there are no damages. The individual can't prove damages. Mary's position on this is there's a distinction between my email address and my home address. I don't care if my email address is compromised. I do care if my home address is compromised. So what's happening in the court systems right now is the closer it gets to a person actually being able to be identified, the courts tend to look differently between credit card data and healthcare records. And you can understand, if you stand back and say, and you think about it for yourself, I could care less if they have my American Express card, because I will fight with American Express, and American Express will give me that money back, and there's no real damages on my part. But if someone compromises my healthcare record and someone fraudulently gets some type of medical fraud going, or they're pretending to be me to get some type of medical service, that's a little bit more personal. And it's not just the financial aspects of it. It's really, what are they actually, it feels inherently different to say you have all of my health care information as opposed to you having my credit card data. And so many of these legislations out there don't have, the citizen can't go, even if it's health care, because HIPAA, which is a federal regulation, doesn't allow individual citizens to sue. As a side note, though, you have some cases that are floating around from a state law perspective that will give a citizen not necessarily the right to sue under HIPAA, but sue under breach of contract, or sue under malpractice, medical malpractice, when it comes to that healthcare stuff. So there are ways you can get around this quote-unquote private right to action, but what organizations would be afraid of in regards to class action litigation when it comes to these huge data breaches, what they're afraid of is that, it's going to hurt their bottom line, as opposed to the FTC coming in and saying, Facebook, pay us $5 million or $5 billion or whatever it is, and it's just a slap on the wrist. The private right of action gives the right to the citizens whose information has been compromised, and privacy legislation currently does not allow for that type of cause of action. So the question that I have for you guys and you can unmute yourselves if you have an answer. Can you have a reportable privacy breach without a cybersecurity breach?
I would definitely say yes.
Yeah, I would say yes.
You can have a reportable privacy breach without a cybersecurity breach. Give me your situation that you're believing that you have to report a privacy breach if it's not in technology.
If you have a printed spreadsheet of PII that is leaked to people that shouldn't have that information.
Okay, we got paper records. What else we got?
Social engineering, that count?
I'm sorry, I didn't hear that.
Sorry, I said something like social engineering, like an internal threat.
Internal threat actor. Okay. Anybody else? Okay. So, generally speaking, the answer is no. Paper records are not actually included in data breach laws, except for, and it's 1, 2, 3, 4. This is the 5th bullet. Except for Washington, Arkansas, Wisconsin, Iowa, Indiana, North Carolina, Massachusetts, and Hawaii. All the rest of the states, if you can lose as much PII in printed records as you want, and it's not a reportable breach, period. It just isn't. Most of the data breach laws in the country, there are 50 states, including the District of Columbia, Guam, Puerto Rico, and the U.S. Virgin Islands, that have data breach laws. Like I said, there's only 1, 2, 3, 4, 5, 6, 7, 8 of them that require reporting of paper records. And so that means for the vast majority of states, if they can lose just as much data from a paper records perspective, and they don't have to tell anybody that they've had that breach. So again, you cannot have, for most states, a reportable privacy breach without having a cybersecurity breach. Each state defines it differently. I picked 4. I picked personal information. They define personal information as different. Some states include healthcare information, even though there is HIPAA. Most states don't. States are now amending their data breach laws to include biometric data and also mother's maiden name. Anybody have a clue as to why, if mother's maiden name is breached, that is reportable?
Passwords.
I'm sorry?
It's a password question.
Yeah, it's a security question. That's exactly right. It's usually a security question, and they are now saying that if that's compromised, you have to report it. So, your covered entities are all businesses that work within that state. Texas had done something different before all 50 states had their data breach laws. Texas residents that lived, companies that had a data breach for residents that didn't have a data breach law, they had to actually report it in Texas. So they kind of sort of, did the big brother type of thing. So you couldn't skirt past the law if, at the time that the breach happened, the citizens that belonged to that state didn't have a data breach law. You still had to report it. Security breaches, how they're defining security breaches is different. Unencrypted data, if it's encrypted, it's usually not reportable. But what's unique, what's happening, what you see in some states is encrypted data is included if the keys were stolen. So if the actual key to unencrypted data was part of the breach, you now have to report that as well, even if it was encrypted. And one of the more interesting aspects is the difference between access versus exfiltration. Okay, so there's a difference so let me go back and say a story. Okay, so while I was working in the corporate environment, there had been incidents, what we call security incidents that were investigated, that you knew somebody was in the system, but you couldn't prove what they did. Now, whether or not you could prove what they did because you didn't have the logs to actually show that they did anything, because that log may not be turned on. So anytime you touch anything that has to do with the computer, there's a log that's being generated about your activity. So if someone accessed a particular file on the computer, if you don't have substantive logging that will tell you what they did with that particular file after accessing, you can claim from a legal perspective, I didn't have a breach because I can see they had access, but I can't prove that they took it. Well, some states are getting hip to that too, and they're saying, no, no, no. If you can prove that somebody had unauthorized access, that means someone came into your network and you see them in your network, and you can't, even if you can't prove that they took anything out, you now have to report that. And that's Puerto Rico, Florida, Connecticut, New Jersey, Rhode Island, and New York. It's a distinction, and what it's saying to me is that the law is starting to catch up with the games that the tech people have been playing with these laws. So, and it's actually really not the tech people; it's the lawyers that have been playing games with access versus exfil. Because I've worked with attorneys, even as an attorney, I've worked with attorneys that will draw that distinction. Oh, well, we know they were in there, but we can't prove that they took anything out. Well, that doesn't mean that they didn't. That means that you don't have the logs turned on to show that they did. So, and then state data breach laws, they vary on the who, what, when, where, and how. In Texas, as of September the 1st, you get 60 days. A lot of data breach law, 60 days to report to the Attorney General or to report to the citizens that information was compromised, that you've had a data breach. Now, the data breach laws apply comprehensively, meaning it doesn't matter whether or not it's reportable to the state Attorney General. If you, as an individual company, have had customer data that was actually breached, best practice is to go ahead and inform them individually of that breach. Here in Texas, if it reaches above 200 residents, you have to inform the state Attorney General. And so, like I said, each law, when I was studying for the CIPP, Certified Information Privacy Professional Exam, I read this section, and even though I went to law school, I was like, oh, this is so confusing. Because each state does things differently. And, you know, if we now take the state data breach laws, and now try to replicate that for privacy laws, it's going to be a complete mess with organizations trying to understand what they should do when they have some sort of breach of information. But getting back to the paper records piece, there are 35 states and Puerto Rico that have data destruction laws, meaning it doesn't matter what you do for a business, you have to dispose of information. Any business that collects PII must be have to destroy the data if they're no longer using it. Okay. So, I mean, my whole thought has been the disconnect between cybersecurity and privacy is our problem, because especially on a large corporate perspective, you have organizations that silo cybersecurity into IT, and they silo privacy into the legal department, and not necessarily even legal. I mean, one organization I work for, oh my God, I didn't even know who to call when there was a privacy, who had ultimate responsibility to report whether or not we lost PII of a particular, of our customers. It becomes, okay, which version, which flavor of legal do we actually call? So that the actual siloing of individual cybersecurity and privacy issues has caused this issue that we have right now, because essentially security problems they're going to continue. We're transferring our problems that we've had internally as an organization to the cloud. We are thinking your average company believes that if they, go out and buy AWS, that AWS is more secure than if they had a server in their own office, and that's not necessarily the case, because AWS, unless you pay for it, AWS does not monitor for security events in your cloud infrastructure at all. They're just providing you with a server or a service. They're not providing you with security for your data. AI, machine learning, IoT, we're transferring a lot of the issues from the technical side into new technologies, quote unquote. And the old problems continue to follow. Breaches continue to happen because we haven't fixed the old problem. And organizations need to understand that they can't transfer that risk to somebody else. You can't transfer your data loss requirements to Amazon or to your IT provider. You as an organization still have to understand where that data is, what you're doing with that data, who has access to that data, how that data is secured, is it encrypted, all of those things, even if you do outsource. So they need to get back together, and that the focus should really be on the data. As you guys listening to me talk about data, that's the issue that we have. So I think we've tried to in so many ways distinguished ourselves, and we've created a whole lot of jobs on both sides. I mean, now you have this whole new field of legal tech. So now the lawyers are getting technology, and they're saying that they have these requirements. And, I've read chief privacy officer, job descriptions that read like chief information system security officer, job description. So there's this internal fight, but what are we talking about here? And essentially what we're fighting about is how to protect the citizens' data. And it doesn't matter whether you call it information security, whether you call it privacy, whether you call it cybersecurity. It's really just a miscommunication in regards to the actual data that you have been charged as an organization to protect. So I ran through that a lot, and I think we only really had 10 minutes. So I really wanted to give you guys an opportunity to ask questions. I know I ran through that, but that is the presentation, and I want you guys to ask questions or pepper me with questions if you have any. I don't like silence. Come on.
Anybody have any questions?
Did you guys understand it? Did I make sense out of it? That I know the audience itself is not necessarily technical or legal. Hopefully I did a good job trying to get you guys to understand it. Did I go high enough level, or did I go into any detail? Are there any specific questions?
Maria wants to know if we can reach out to you if we have questions that we run into in the future.
Oh, absolutely. There's my email, there's my phone, there's my website. You have all of that. Connect with me on LinkedIn as well.
I don't think it was too high level. I think it was good. I don't have any specific questions, but it was a good presentation. I appreciate it.
So Mary, I had a question, and it's more current events related than anything specifically from the discussion. But I was just wondering your thoughts with the different federal courts ruling differently on whether a person can be compelled to disclose their mobile phone passwords and that their protections over self-incrimination. And when with the recent court case, I forget the court case name, but about that it was a foregone conclusion that they would have access to the device. What are
But
your thoughts on where that'll come out?
it
Since
all
different,
depends on the facts. Okay, so when you're looking at that, because there are cases, and when you're looking and you're trying to compare it, you have to compare the facts because that's what lawyers live in, right? You have a fact pattern where you have a search warrant that has been issued for a particular person, and they have in the search warrant all of the devices and, you know, all their computers and everything like that. That they have access to if they've actually determined that they're a cyber criminal. The passwords themselves could be included in that search warrant. But then you have a situation where if you're coming to my house for a search warrant because I'm selling, bootleg videos. Let's go back to when I was in FBI. They don't have those anymore. But I'm selling bootleg videos. No, that's a bad example. Let's say I'm selling supplements, right? Out of my garage or whatever. And if the law enforcement officer doesn't put in that particular application for a search warrant that my devices are included, or if the search warrant doesn't include the fact that my phone is actually something that's part of this search, or they think some criminal activity has happened on this phone and they don't put that information in there. You come in my house on one particular issue, and now you try to compel me to unlock my phone. Courts have said, there have been court cases that said you can't do that. That is a violation of Fifth Amendment, Fourth Amendment, right, of self-incrimination and things like that. So it all depends on the facts of the case and what that search warrant says. The problem that law enforcement is facing right now is you just can't go in and assume that you're going to have access to all devices if you cannot connect that device to the crime that you're actually serving for that search warrant. Does that make sense? So each individual fact pattern is different, and there is conflicting laws, and those conflicting laws are based on the facts of the individual case. If you're coming at me from a drug perspective and you have no reason to believe that I'm using my phone to conduct any activity, or you fail to put that in the search warrant, you can't compel me to give you my thumbprint. You can't compel me to unlock the device. You can't compel me to put my face up to the phone. That's an illegal search, because you need to have probable cause in order to conduct that search. You need to have probable cause to believe that this device has evidence on it. So you have to, when you're looking at those cases, look at them from the fact pattern perspective. There's no general law that's going to say this is a go and this is not. It all depends on the facts.
Okay, yeah, that makes a lot more sense, because it's something I've heard discussed several times on tech podcasts, but those are, technologists, not lawyers. So they definitely give different impressions, and yeah, yours makes it a lot more clear on why there's the discrepancy between different court cases, because clearly they have different fact patterns, and makes a lot of sense now.
Yeah. That warrant has to be as a former law enforcement officer. Again, I investigated cybercrime, so we wanted everything, right? But the whole compelling of a person to unlock their phone or anything like that, you get into muddy waters unless you can prove that there's no other way you can get that information and things like that. If you didn't have a FISA, you weren't sitting on a wire, you weren't doing anything like that. So you have to understand the facts.
All right, thank you.
Anyone else have any questions? Well, hopefully I provided you guys with some good information. Hopefully it wasn't too techy or too lawyerly.
People said great presentation. Thanks.
All right.
Yep. All right. Well, if nobody has any questions, I guess we can close it out. I want to say thank you, Mary, for coming.
Well, thank you guys for having me. I really appreciate you guys having me. And like I said, if you have any questions, feel free to reach out.
Thank you so much.
All
Have a
right.
good night, everybody.
All right. Good night.